Whether you're married or not, separating from a partner can be a difficult time, both emotionally and practically. It is also very important to understand your legal rights and obligations. If you have been living together in rented accommodation, will you both move out, or will one of you continue to live in the property, either alone or with a third party? If you're both going to be moving out, you'll need to look at your tenancy agreement in order to see how much notice you need to give. You also need to be aware that if both of your names are on the tenancy agreement, then you will both be responsible for the rent until the end of the notice period. It is important to realise that if one person gives notice, it ends the tenancy agreement for both of you. Therefore, if one of you is intending to stay in the property, either with a new flatmate or alone, you will need to contact your landlord in order to agree a new tenancy agreement, which includes the new person, if there is one. If you have purchased a property together, then things are a little more complicated and will depend very much on whether you are married or not. If you are married, then what happens to the property will need to be resolved as part of a wider agreement about how to divide all of your assets between you. If you are not married, things are very different. Will one of you be buying the other out of the property? There will be lots to think about. The property will need to be legally transferred from your joint names to one person's name only, and so will the mortgage if you have one. You will need a solicitor to help you with this. The person keeping the property will need to pay stamp duty on both the amount paid and the share of the mortgage that is transferred if that total amount exceeds the stamp duty threshold. So this is something to consider at the outset. If there is a mortgage on the property, it is important that you speak to the mortgage company, as they will need to agree to the mortgage being transferred into one person's sole name. If they won't agree, the person keeping the property will need to apply for a new mortgage in their name only. If they cannot get a mortgage in their own name, then the property may need to be sold. Assuming the transfer from joint names to one person's name can go ahead, then a major issue that you will need to resolve is the price. The easiest thing to do is ask a few local estate agents for their view of a fair value of the property and try and reach an agreement from there. If you cannot agree, you may need to pay for a formal valuation. If you agree that the property should be sold, then as long as you agree the proportions in which you own the property, things are quite straightforward. You will simply need to cooperate in instructing estate agents and a solicitor who will deal with the transaction on your behalf. However, things get much more complicated if you do not agree the proportions in which you own the property. If you feel that you should be entitled to more than half of the equity, you will need to take legal advice. Whatever your situation, you should always find out your legal position before taking any action, as it will allow you to make properly informed decisions.